This is a suspension matter.
This is the matter with regard to that inquiry against the district council.
Okay.
Your Lordship has already passed an order whereby any report submitted should be kept in sealed cover till disposal of the writ petition. So the inquiry also is still going on.
So there is an acting CM in place. Hello?
I'm for the petitioner.
How
3
long?
weeks, Lord.
2 weeks.
No objection.
On preliminary petitioner seeking accommodation. Same not being objected to by respondent. Matter is adjourned. List the same after 2 weeks.
Obliged.
Please, Your Lordship. Lordship, item number 8 is an appeal. My Lord, on the last occasion, Lordship was pleased to direct us, the appellant, to prepare an informal paper book. Slightly embarrassing, my Lord, but it completely slipped our mind. 1 week may kindly be granted to us. We'll prepare the paper book.
On preliminary appellant, list this matter for 1 week.
Obliged.
Please, Your Lordship, I beg to mention item number 4, Your Lordship. Your Lordship, let the matter may come up. Yes, sir?
This matter was heard.
Part heard matter, Lordship.
Part heard. Mr. D.
Yes, Your Lordship. Done.
On preliminary appellant, this is matter of the
Next week, Your Lordship.
1 week.
Highly obliged, Your Lordship.
Daily list item number 1.
May it please Your Lordship, on the previous occasion we have been directed to effectuate the service to the de facto complainant. Your Lordship, we've taken steps and have effectuated the service to the de facto complainant by way of Talabana, Your Lordship.
Any report?
As of now, no, Your Lordship.
Ms. Learned Counsel for the petitioner has submitted that on being directed by this court, steps have been taken for issuance of notice upon the respondent number 2. However, till date, no service report has been. However, till date, there is no report as to whether this said notice was effectuated or not. This being the case, it is prayed that some more time may be allowed for such report to be filed. On private, this is matter up to 2 weeks.
Yes, Your Lordship.
1 week or 2 weeks?
2 weeks, Your Lordship.
2 weeks.
Much obliged, Your Lordship.
Item number 2.
So I go to you, Mr. Ndishulai, AG appears for the respondent, state respondent. Yes.
Please, Your Lordship. I am yet to receive further instructions in this matter. I am praying for 2 weeks' time, Lord.
Yes, anything, Mr. Samar?
No objections. Let them file the affidavit.
Mr. SL Leonard J has sought for some more accommodation. Has sought for accommodation on the ground that the instruction sought for has not yet been received. On primate, this matter is on primate, the same not being objected to by the Learned Counsel for the petitioner. List this matter after 2 weeks.
I leave my word.
Item number 3.
Lordship, respondent 6 some more time, Lord, if I may ask.
2 weeks time may be granted.
2 weeks.
No, pray for 3 weeks time.
Why?
No, we're still waiting for instructions from the department.
By now the EC must have been settled. How many months have passed? Since the
I cannot make a submission on that.
since the formation of the last half of the new EC, by now things should have been in order. Anyway, 2 weeks. Mr. CCT someone learned counsel for the respondent 6 on oblique KHADC has once again sought for some more time to file the counter affidavit on the ground that specific instructions have not yet been received in this regard. On prayer made, same as the law. On prayer made, the same not be objected to by the learned counsel for the petitioner. This matter is now posted after 2 weeks.
Outline.
Item number 5.
My lord, we have taken steps, my lord. I have even written to the department. Till now, I have not received any instructions, but we are positive that some instructions will be coming, my lord. So, my lord, I'm making a prayer that this matter may come up again after 2 weeks, my lord. In the meantime,
See, Mr. Gautam,
yes, my lord.
what is the necessity for you to write,
My lord.
to, to file, write a letter informing them? It's just a.
My lord,
phone
I have
call.
done my part, my lord. I have not
You
received
could
any
just
instructions.
Take initiative and say, this is what the court desires. What are your instructions? What steps to be taken? It's as simple as that.
Yes, my lord. My lord, we have done that, but probably in view of these long holidays that were there, so I have not received any instructions, my lord. So if for one last opportunity is given, my lord, we'll try and settle the matter if it is possible. We are all.
It should be the endeavor of the parties.
My lord, ample
Otherwise-
notices have been given to the department.
Otherwise, see, the court is,
Of
it's
course, my lord.
incumbent upon the court to take up the matter on merits.
My lord. My lord, we are. Lord, if something comes up, my lord, we can sit across the table and sort it out, my lord, because it's a long pending matter. Of course.
Yes, Mr.
My lord, your
any
lordships have already
response?
indicated. My lords, we have not received any instructions. Neither from the department nor from the council. Because here.
My lord, I have, on the last occasion, my lord, I have written to the department incorporating their letter as well as the orders of this court, my lord. I'm awaiting instructions on that. So, my lord, I'm praying that let this matter again come up after 3 weeks. So, by then, if we have.
My lord, since December, we have approached the department. Until date, they have not taken any steps. Your lordships also made it clear on the last date that failing which necessary orders shall be passed by the Honorable Court.
My lord, one last opportunity may be given, my lord. The rest, of course, is the court's
You get your
discretion.
proper instruction.
Yes, my lord.
This way, that way, whatever the case may be, the court will record that.
All right, my lord.
Because since the court has given, given the party the, I would say, the chance to try and settle the matter outside court in a very, I would say, cordial atmosphere, where, if you sit across the table, there should be, or there must be, or there would be some give and take.
My lord. My lord, from on their part, they have
They
said
have
that,
not even
that they are
intimated
going
my
to set off 25% of the decretal amount.
You see, that is not for this court to decide.
Of course, my lord. Of course.
See, it's for you to decide
My lord.
whether you accept it or not. It's up to you. But at least you should indicate that you have sat over the matter, decided whether to accept it or not, and the matter can proceed. Otherwise, just keep, it's a very, old matter.
Old pending matter,
2016,
2016.
10 years, almost 10 years now.
My lord, one last opportunity, my lord. 3 weeks, within 3 weeks, my lord, we'll pay some instructions, whatever it is, my lord.
Mr. Nampir, what about you?
Same, because this involves the government also. Approvals will be required. Files have to be moved. Sometime
He's appearing for this sports council, my lord. I'm appearing for
Or you
the.
for the state?
I'm for the state, my lord. The
For the sports
director
council.
sports.
Sports council.
But in fact, we have intimated
This
both
requires
the,
department,
even the state government as well as the state sports council. Through a letter, we have intimated them as well.
Yes, of course, they are in the know. You can't say that they do know.
Actually, we're not denying that steps have been taken, but it involves government policies and decisions, Lordship. File has to be moved and deliberations has to be taken up. So some time may be required. Lordship.
General counsel for the respective parties have submitted at the bar that specific instructions from their clients have not yet been received as to how to proceed with the matter as far as the issue of settlement outside court is concerned. It is prayed that some more time may be allowed for such specific instructions to be received and this court to be apprised of the same. On consideration of the submission made, this court hereby this court would request the parties to proceed with the matter expeditiously, considering the fact that this is a very, very long pending matter. How many weeks is it?
3 weeks, my lord.
On prayer made, this is matter to 3 weeks for report.
Item number 6.
Well, this is that matter relating to non-payment of full benefits under the VRS scheme.
This matter has been heard.
My lord, I have made partial submissions, my lord. My submissions are not complete.
And today we thought that we'll make 1 to 4.
On behalf of the state, my lord, I am paying for some time. Because my lord, the council, conducting council is Ms. NG Sharma. It's not available today.
I am appearing on behalf of the respondents 5 and 6, the MIDC and the MEDCL, Your Lordship.
MIDC?
MIDC and MEDCL.
Well, then Mr. Gautam can continue with his submission, with his argument, and you can reply.
Let him continue. We'll make a submission on the next day because we are on the same page and we would like to be together.
Yeah, there you can take down notes and brief the council.
Finished.
Now, my lord, just to take my lord back to the facts of the case now. Now, my lord, the MEDCL, my lord, a subsidiary of the subsidiary company of the MIDC, my lord, was decided by the it was decided by the government that they will wind up the company, my lord. So accordingly, my lord, the employees were offered a voluntary retirement scheme, my lord. Now this scheme was offered in 2 stages. At the early stage, when 59 there, at the early stage, the first set of employees, they were given the VRS. Now, my lord, when they were given the VRS, my lord, they were given VRS in one go. They were given the benefits of the prevailing pay commission, and other benefits were also given to them, my lord. Now, thereafter, my lord, 17 of the employees, out of the total employees, 17 were retained. Now these 17 employees include the petitioners who are before your lordship. Now my lord, they were retained on the understanding that the corporation will venture into new arenas, and accordingly they will be absorbed. But that was not to happen, my lord. What happened after the company was liquidated at the earlier stage? Then subsequently, what happened, my lord?
This is the MEDC or MIDC?
MEDCL, my lord. MIDC is the parent company, my lord. These are under the Directorate of Industries, my lord.
So they are subsidiaries,
My lord.
more or less.
MEDCL is a subsidiary of the MIDC, my lord. MIDC is the parent company.
Exactly.
Now, my lord, here what happened then subsequently, my lord, these 17 employees, my lord, though they were kept with the understanding that they will be absorbed into a different venture that will be taken up by the MEDCL, but that was not to be, my lord. A company which was once producing tantalum capacitors and other things, my lord, it was virtually reduced to a sales agent of SAIL. Now, the employees, that is the petitioners before your lordship, continued to attend their offices till 2012. Now, my lord, then thereafter, the government decided that the remaining 17 people will also be given VRS. Now, accordingly, they were asked as to what the authorities were asked as to what will be the fund requirement for granting them VRS. Now, my lord, if my lord will kindly come to I'll just take my lord to the relevant annexum now. Now, my lord, the fund requirement, my lord, if the company was to be, one second, my lord, I'll just have the relevant annexure. I had already submitted on the last occasion, my lord. Where is that? My lord, the fund requirement, my lord, if the company was to be liquidated on 31st March 2009, that means if all the liabilities of the company, which by liability I mean the salaries that was due to the remaining of the 17 employees, if they were to be paid as on 31st March 2009, my lord, the fund requirement of the government was about 245.68 lakhs. That is 2 crore 45 lakhs and 68,000.
What is that?
My lord, that my lord will find at paragraph 12 of the writ petition. My lord, that's submitted on the last occasion. It's at paragraph 12.
Okay.
Now, my lord, this was the requirement if the funds were released on the 31st of March 2009.
Yes.
However, that was not done, my lord. Now, what actually happened in this case was
the funds were not released in one go. Now, my lord, a VRS, what is a VRS, my lord? A VRS is basically, it is a contract, my lord. It is a contract. Now, my lord, the contract becomes complete once the entire payment is made to the employee. It is a one-time package, my lord. A VRS basically is a one-time package given to the employees on account of the, say in this case, my lord, the liquidation of the company, or in account of the fact that it is no longer profitable for the employer to carry on with the business. So therefore, my lord, what a VRS is given, which is also commonly referred to as the golden handshake. Now in that golden handshake, my lord, one package is given. Now once that package is paid in full, the jural relationship between the employer and the employee cease to exist. Till the time the payment is not paid, the payment is not made, my lord, the golden handshake is not complete, and the relationship continues. That means I continue to be an employee entitled to all the benefits that an employee will be entitled to otherwise, till the time the full payment is made. Once the full payment is made, my lord, the relationship cease to exist. Now in this case, that did not happen. Out of the total fund requirement as on 31st March, which was 245 and 68, now this were released in parts. They release in parts in three installments, my lord. In 3 installments they release these. Firstly, they release a sum of, out of this 245. Firstly, for the in financial year 2009-2010, they release a sum of 1,12,20,000, and another sum was released in financial year 2010-2011, which was 1,13,042.42. That means 1,13,42,000. However, the entire money was not paid. The last known payment was made sometimes in the year 2014. Now, even then, after the payment was made in 2014, then in the meanwhile, what happened, my lord? The government of Meghalaya implemented the 4th pay commission. Now the 4th pay commission, it came into effect in the year 2009, but the benefits were given with effect from 2007. Now the director of industries asked the deputy secretary of the Department of Commerce and Industries asked the director of industries to furnish what is the fund requirement. What is the fund requirement for final settlement of the VRS, to the petitioners. Now this was done by Annexure 2. My lord, Annexure 2, my lord, will file at page number 29. Page number 29 of the writ petition. Yes, my lord.
Yes.
I am directed to invite a reference letter number so and so from MIDC, a copy of which has been forwarded to you, and request you to submit a revised fund requirement to the government for final settlement of VRS or Golden Hand scheme with implementation of the 4th pay commission by the government of Meghalaya in respect of the staff of the MEDCL. Now, my lord, accordingly, White Annexure 4. White Annexure 4.
Yes.
White annexure 4, my lord.
Yes.
The requirement was furnished. Now, as per the requirement, my lord, a sum of rupees 2 crores 90 lakhs 0.84 was required to be paid to the employees if the VRS is implemented on July 2011. So, my lord, if July 2011 is to be taken as the cutoff year, a sum of rupees 2 crore 90 lakh and 84,000 was required to be paid to the employees. Now, my lord, this was communicated white letter dated 24/5/2011. But this sum was also not paid, my lord. This sum was never released. The petitioners continued to work till 2012. They were attending offices regularly. Thereafter, they were not allowed to attend the office.
See, when at the time when they were working,
My lord.
since the scheme was introduced,
My lord.
and it was offered them,
Yes, my
but
lord.
they continued to work.
They continued to work, my
Till
lord.
2012,
Till 2012, they attended office.
they were paid their monthly salary.
They were paid, my lord. Paid. I'll have to take instructions on that, but I do not think, my lord, they were paid regularly or.
They were paid up to 2012, Your Lordship, because subsidiary company had already stopped working since 2005, which is why 42 of them were given the VRS in December 2005, the golden handshake. There was no work being done in the subsidiary company. These employees, 17, were retained with the intention of diversifying or reviving the company. Your Honor. But that could not be done because it started incurring loss even in the different projects and schemes, which is why the 17 employees were also asked to take VRS, Your Lordship. Till 2012, they were given, and the parent company, the subsidiary company is a separate legal entity, Your Lordship, and they have been taking loan from MIDC to pay their employees. If they cannot pay themselves, the parent company was helping them by giving them loans, Your Lordship. So till 2012, these subsidiary, the employees of the subsidiary company have received their salary, Your Lordship.
So, see, till 2012 or thereafter,
there was no work being done, but they were given on humanitarian grounds.
Was the MITC, was it winded up?
No, my lord.
You see,
Till date, it is not winded up.
Because of the disputes, because of this case, the disputes, until and unless everything is clear, but there is, the balance sheet is nil. The MEDCL's balance sheet is nil, Your Lordship. But because of the disputes regarding the employees asking for their, what do you call that, VRS and all that, and the government also due to financial constraints could not pay in time. So this matter, and now because of the pending case, Your Lordship, officially it has not been winded up, but there has not been no work being done since 2005.
That is, you see, that's beside the point.
That is beside the point, but
then the fact remains that you are still responsible for your employees.
I am responsible for my employees, but I have no income, Your Lordship. Be that as it may,
that is a different aspect of the matter.
Let them.
The only thing is the code. See, when now we're talking about the scheme, VRS, it was offered, not yet implemented.
387 point something lakhs has already been paid to the employees.
These 17?
Yes, Your Lordship. 387 point something has already been paid. But they are insisting that they should get it as per the Fourth Pay Commission.
Whatever the case may be. See, now the only...
So their balance, they are asking for the balance.
Yes, perhaps the dispute here would be with regards to areas.
And the balance, because they are claiming under the Fourth Pay Commission. Whereas the government has clearly told them that they cannot be paid under the Fourth Pay Commission, but as per the Third Pay Commission, it has been cleared.
See, Ms. Yangi, if they have been disbursed the part of the the proceeds of the scheme, why would they continue to receive salary in the meantime?
Till 2012, they have received. Because it was
being
paid in parts. It was being paid in parts.
My lord, there is no denying to the fact that the jural relationship, my lord, since the the golden handshake is not complete, there is no denying to the fact, my lord, that the jural relationship still existing, my lord. That will come to an end only when the final payment is made. Now what happened, my lord? In the meantime,
contention.
my lord, in the meantime, they have taken a unilateral decision that their cut-off year will be 31st July. Now, my lord, if this cut-off year will have some meaning if the money was paid within that time. But the last known installment was paid in the year 2014. The last installment was paid in the year 2014. Even after paying the third installment, my lord, by their own admission, there is a sum of 1 crore 81 lakhs, which is yet to be paid. My lord. Which is yet to be paid, and this is by their own affidavit. This is borne by their affidavit, my lord. Time and again they have sent the proposal to the government, and the government has not rejected the proposal. The government has said that the proposal may be kept in abeyance for financial constraint. There is no rejection, my lord. There is clear admission of liability. My learned friend herself submitted that salary was being paid till 2012. Now, my lord, however it is paid, my lord, it's a subsidiary company. A subsidiary company is like a child, and the holding company is like the parent company. The parent company is liable for it, and then they, by their own admission, my lord, there was a board meeting, my lord. In the meeting of the board of directors, my lord, it was resolved that all expenses relating to liquidation of MEDCL will be borne by MIDC, holding company. My lord, this is the resolution, my lord. This is the resolution, and this is there in their own affidavit, my lord. I'm referring to their affidavit, my lord. So otherwise also, my lord, when there is a holding company, my lord, the subsidiary company fails, the liability automatically will shift to the holding company, my lord.
That's not the law.
See, but you see, let's assume a situation where from 2012,
my lord,
till 2014,
my lord,
you may be still, you see, legally or officially still employees,
my lord.
But the fact remains that the company is dysfunctional. Practically, there's no work done by you. Is that the case?
No, my lord. It is not that. It is not that, my lord. If we are not doing any work, for what were they paying us? We were there. We were attending office, my lord. And even, my lord, when
the company was still functioning then.
Yes, my lord, the company is still functioning. When this matter was, when a motion was made before this court, my lord, a query came from the court. Two queries came from this court, my lord. One was whether the company whether the liquidation of the company is over, whether the company has been wound up, if there is a closure certificate, and what is the status of the proposals. Now, to that effect, my lord, additional affidavits were filed. Where is that affidavit? Now, my lord, in this additional affidavit, it is admitted that the winding up of the company is not yet over. Till now, there is no closure certificate, my lord. They still have a director to look after the winding up of matters of the company. Now, secondly, on the question of admission of...
So, we can say that till date, the company has not yet been declared as insolvent.
No. It is still there.
Because
it is still there, my lord.
If that is the case, then you see situation change.
It is still there, my lord. It is not complete, my lord. How can it be complete when the liabilities are yet to be paid? Winding up is over when all the liabilities are cleared, my lord. Now, in response to the queries put forth by the court, an additional affidavit was filed. My lord, this additional affidavit is dated sometimes in September 2004. September 2024, my lord. Now, my lord, this affidavit makes it very clear that time and again a proposal was sent to the government. Now, these proposals have not been rejected, my lord. they have postponed it to other financial quarters. Now, my lord, if my lord will kindly come to that affidavit, this affidavit filed by the respondent number 4. What is the affidavit there?
State.
Yes, my lord. The Director, Commerce and Industries.
Yes.
Now, my lord, kindly come to Manager 1. Page 5, my lord.
Yes.
With reference to the above, I am submitting a fresh proposal for an amount of so and so, so and so, so and so for meeting the expenditure of the VRS of the employees of the MEDCL. It may be mentioned that the budget provision for the current year is rupees 2 lakhs only. I am therefore requested to kindly accord sanction of so and so from the budget provision under the head account, other expenditure, voluntary retirement scheme of sick unit, pensionary charges, general, wide budget volume so and so. The balance amount of so and so may kindly be sanctioned by advance from contingencies fund under so and so. Now, my lord, in response to this letter, the response to this letter is that I am directed to inform you that you are advised to come again with the proposal for consideration in the last quarter of the financial year. This has the approval
Where
of
is
the
that?
the next page, my lord, Annexure 2. Annexure 2 of the additional affidavit.
Yes.
This has the approval of the competent authority. Now, Annexure 3 again, page 7, same proposal. And the reply is to come up with the proposal in the next financial year. Then then Annexure 7, my lord.
Yes.
Annexure 7, that in view of the fund constraint, the proposal may kindly be kept in abeyance. So, my lord, clearly it is there. They are admitting, my lord. It is I submit from their documents itself, my lord, that there is a liability, my lord, and that liability needs to be met. It cannot be said that some kind of charity is being done to us, or out of on humanitarian grounds payments are made. You know, these are our salaries. These are our hard-earned money. This is their liability, their obligation, and this is our entitlement, our right. Now, my lord, even if they have said constraint, maybe in view of fund constraint. Now, my lord, MIDC has many subsidiary companies working under it, which have been liquidated, or which are in the process of winding up. The cement corporation also is in the process of winding up. There is no fund constraint, my lord. What is there is the lack of willingness to pay. Meghalaya Bamboo Chips was also, my lord, the employees of the Meghalaya Bamboo Chips were also given the golden handshake. One-time payment was made to them, my lord. Now there is a proposal in the pipeline that the same offer will be given to the employees of the MEC of the MCCL, the cement corporation. So why should we be treated differently, my lord? It is not the case that they are conversing that they have paid us everything we are not entitled to. We are agitating for no cause. Clearly, my lord, we have a right and that right is admitted by them.
So now, is there any issue as far as the quantum is concerned?
My lord, there is an issue, my lord. Now, my lord, the VRS, as I had submitted earlier, it is a contract, my lord. It is a contract. Now, my lord, the VRS or the golden handshake is complete only when the full payment is made. The full payment, till the time the full payment is made, my lord, we have certain entitlements. They have fixed a cut-off date, my lord. I had submitted on the earlier occasion, my lord, that they in their 101st
July 2011.
Yes, they had fixed a cut-off date. How was that cut-off date fixed, my lord? It is a unilateral cut-off date, my lord. Can there be a unilateral fixation of a cut-off date in a contract? What is a VRS, my lord? It is a scheme. A VRS is an offer. It's an offer made to the employees. It is not a case of compulsory retirement. It is voluntary retirement. Voluntary retirement implies consent.
True. When the scheme was offered to you, you had accepted.
Yes, we had accepted. But we had accepted.
So the scheme is set in motion.
Yes, it was set in motion, my lord.
If a cut-off date is given,
my lord,
within such date, the purpose of the scheme is to be fulfilled.
Yes, my lord.
Then that matter ends there.
The matter ends there, provided
because of the fund constraint, as has been submitted,
my lord,
it could not be completed as on 2011, and it has travelled till
2025. Now, my lord, to that I bow down, my lord. But what has happened in these years, my lord? There are other companies which have been receiving, other subsidiary companies of MIDC who have received the benefits, my lord. Why should we be treated differently? My lord, that cut-off date would have had some meaning if and only if, my lord, if I may submit, if and only if the entire payment was made on that day.
Exactly, that is true.
The last known payment is made in 2014. So, my lord, I ask myself, are we not entitled to at least payment till 2014?
So you mean
I might have fumbled on the figures.
So you mean to say that till 2014, you have been paid some amount?
Yes.
2014, on 2014, we were paid one installment.
True.
One installment, but that was not the complete thing.
Exactly. Now what remains?
According to them, by their own admission, it is 1 crore 81 lakhs something.
What is, you calculate that in terms of percentage. How much have you received and what is left? Repeat.
My lord, for that I will have to give you bullet points, my lord. I will do that since the counsel appearing for the state is also not there, my lord. I'll come with bullet points, my lord, because there are certain figures, my lord. I fumble with figures. So I'll have to come up.
As far as I can understand, if
my lord,
I can understand it properly,
my lord,
the scheme was in motion. It has been, it has been implemented to a certain extent.
Partially,
whatever.
My lord.
Exactly, partially.
Yes, my lord.
Now you have been paid certain percentage.
Yes, my lord.
Perhaps now what is remaining, what remains to be paid to is 40%, 30%, 20%, whatever the case may be.
My lord.
Now that is to be calculated as from 2014.
My lord.
So till date, now what, you see, you have to make a calculation.
My lord.
That since 2014,
I'll come up with all
till date, this is the amount that is to be paid to me, either individually or as a group, whatever the case may be, and this has not been paid. And this amount includes so. Maybe,
I'll come up
I don't know whether you are claiming interest, whether you are claiming...
We have claimed only up to 2014, Your Lordship, because the last payment we had made was in 2014.
Well, we have been very liberal on that.
As per the writ petition, they're saying that since it could not be, the final payment could not be made, So they are not asking up to 2025, Your Lordship, because that way. And another thing, Your Lordship, anyway, when I make my submission, I will clarify certain points, Your Lordship,
miss.
which has not been placed before Your Lordship by my friend here.
Madam, I can understand that. You are not admitting that they are not entitled to the remaining dues. What you could have done is you could have
Your Lordship, there are certain resolutions, minutes of the meetings, which has been annexed, but has not been brought to your notice today. I will bring all those.
I have read out everything on the last occasion.
When I make my submission, because the government has already rejected. They're saying that they cannot be paid as per the Fourth Pay Commission, and that was in 2015, Your Lordship. But these people kept on pestering the government, meeting the government, and so certain correspondence have come up even after that, Your Lordship. Because since they were not working, they had already stopped working prior to 2008, Your Lordship. The Fourth Pay Commission is not applicable. And first and the foremost thing is that, Your Lordship, these petitioners, Your Lordship, are not government employees. They are the respondent company number 6 is a registered company. They have been incorporated as per the Companies Act, Your Lordship. So they are to sustain themselves. As long as the company is functioning, they will get their payment, Your Lordship. So when it stopped functioning, then that is why they were asked to wind up the company. But because of the dispute raised by these people, Your Lordship, the company could not be officially wound up, although the company has become a sick unit. There is no production, no manufacture, no income, nothing, Your Lordship. And those people have been paid till 2012. On humanitarian grounds, Your Lordship, by taking loan from the parent company. And Your Lordship may kindly also take note, Your Lordship, that the parent company is not liable to pay the salary of the employees of the subsidiary company. The government or the MIDC has not given them appointment letters. They have been brought or employed by the subsidiary company. And when they were employed by the subsidiary company, they knew fully well, Your Lordship, that as long as the company is running and can sustain itself, they will also be getting their thing, Your Lordship.
Oh, that is the nature of things. Of course.
Yes, Your Lordship. So now and the government has been kind enough to pay 387 lakhs point something to the 17 employees, Your Lordship. And we kept, and they have clearly stated in one of the meetings that the government cannot apply, they are not entitled to the Fourth Pay Commission because they had stopped working prior to the implementation of the Fourth Pay Commission. So anyway, Your Lordship, I will come to all that. I will give a proper submission on the next date. Your Lordship may kindly... My friend has finished, because my friend has, what he has said today, he had already finished his argument on the last date. But
my lord,
anyway,
I will be submitting bullet points, my lord, on this. Now, what my friend is trying to say here, my lord, it is a complete, in complete contrast to the subsequent affidavits that have been filed. And whether they are government employees or not, my lord, they just can't say we are not government employees.
No,
on what basis?
Government employees. The State Bank of India is formed by an act. Insurance company,
correct.
Your Lordship, these are all.
My lord,
I think as far as the nature of their employment is concerned, I think that is not an issue here.
It is not an issue,
because
my lord. Now, my lord,
they are being projected as government employees, and that they are entitled, and it's the obligation of the government to pay them whatever they have asked for, which is not the case.
Entitlement would be based on the obligation that is, cast upon you.
Yes. But whether I have any obligation, law says that a parent company, a government, we are not obliged to make any payment to the employees of the subsidiary company.
We have to go to the terms of employment.
Yes. Let them produce the appointment letters, Your Lordship. The government has not given them appointment. The MIDC has not given them appointment.
My lord.
They were employed by the MEDCL itself, Your Lordship. And MEDCL will pay them as long as...
True. You see, MEDCL is obligated to pay them.
Yes.
How it gets its fund is not their concern.
It is not their concern. But when it stopped functioning, Your Lordship...
whatever is due to them has to be paid.
387 lakhs has already been paid, Your Lordship. And they've got their salary till 2012. They were not working even then. They just went and attended office. That doesn't mean they were working. They were not generating any income. So how do you...
They are not generating any income. On what basis they were paying us? Now, my lord, so far Fourth Pay Commission is concerned, my lord. The Pay Commission, recommendation of the Pay Commission is based on My lord, the pay commission recommendation clearly says that the benefits thereof will go to all civil employees of the government of Meghalaya. My lord. They come within this. That is why they were entitled to the benefits of the third pay commission. So on what basis was the earlier payments made? On what basis was the earlier set of employees released with the benefits of the third pay commission if they are not entitled to this? My lord, of course, after my friend submits, I reserve the right to submit on whatever point my friend has to submit. But on the next day, my lord, I'll furnish bullet points, my lord, along with the calculation.
So
I'll
when?
make my submission on the
Next
next.
Next week.
Next week. Next week, or I don't know, because I'm told that my Mrs. Schiller is out of station. I'm not sure when she is returning. 2 weeks, Your Lordship.
My lord, if I may pray, my lord, since my learned friend is here appearing for MIDC, my lord, now an issue has come up in view of these annexures that there is fund constraint. If my lord is pleased to pass an order asking my friend to bring in records for the benefits paid to the employees of the Meghalaya bamboo chips.
No, that is not even a part of this pleading, Your Lordship. So why should they be? No, Your Lordship. This is out of pleading, Your Lordship. How can a court pass an order to that? We are not concerned with bamboo chips, Your Lordship.
As far as the MIDC is concerned, I don't think that would be,
my lord,
relevant.
MIDC is the same company, my lord, who is a parent company for those for bamboo chips also.
So, but that is not a point of issue here, Your Lordship. How can they ask for make such a prayer? It is out of the pleading, Your Lordship.
My lord, we are only asking for equal treatment. My lord, people standing on the same foot has to be given.
Stated that in your petition.
Oh, then you see, you have to come up with the statement or
I will file in that case I will file an affidavit, my lord. Permit me to file an affidavit.
As far as the relationship between the holding company, that is MIDC, and the
subsidiary company,
what are their liabilities?
Law is very clear on that, Your Lordship. As per the Companies Act, as per the Companies Act, Your Lordship, holding company has got no obligation.
If the holding company is, yes, if you say has got no obligation, we'll have to look.
That defies the entire definition of a holding company.
Now, if you say that yes, they are liable, then that has to be taken into account.
What the government has given them is because out of humanitarian considerations and good governance, Your Lordship. Not for anything, not because they feel that they are obliged to pay, Your Lordship.
So for good governance, they have paid for so many years. That is what my friend is trying to say.
Yeah, what is wrong with that?
We'll see. We'll examine all those
points will have to be examined. Whether the parent company and the holding company is obliged to pay the subsidiary company, and whether
exactly.
My lord, now we are only on facts, my lord. When we come to law, I'll place the law also, my lord. In the meantime, my lord, I'll have to file an affidavit, my lord.
Why?
I'll file an affidavit bringing on record, my lord, how the other companies, companies such as the Meghalaya bamboo chips and other, they were paid out because they have made a case of fund constraint, my lord. It is coming from the same exchequer.
Going out of the context.
We have come too late in the day.
And as it is, Your Lordship,
we are already the fag end of the matter.
Now, my lord, kindly see, my lord, kindly see. In their additional affidavit, my lord, in the last annexure, they have said fund constraint, my lord. Clearly, they have said that the only reason why the sum of one
by whom?
Not by us, not by us,
by the MIDC or by the government.
My lord, the government has said this.
So let them
my lord, it is the government who pays. The MIDC, who funds the MIDC? It is the government. Who funds MEDCL? It is the government.
Yes,
they are all government.
Let the government
explain.
Yes, let her.
So in that case, my lord, let me file an affidavit, my lord.
Why should he file an affidavit at the fag end of the case, as Your Lordship has already pointed out, Your Lordship? Then the whole matter will get delayed.
Then how is my lord going to adjudicate the matter conclusively, my lord?
You see, the only thing that you have to convince this court is as far as the relationship between the holding company and the subsidiary company is concerned. What are the
liabilities,
the contours of their liabilities, their hold and their control, even
the control
as far as the employees are concerned, in terms of appointment, qualification, so on and so forth. So that has to be looked into. then we can see that yes, MIDC is the holding company having absolute control over the subsidiary company and its functioning, which extend to employment, employees, so on and so forth. So once that is established, you don't need to go into all those bamboo chips and other things.
But that is a different matter, Your Lordship. It is not a part of this case.
If they are liable, they are liable.
My lord.
Yes.
If my lord will see the affidavit filed by respondent number 4, my lord.
That is
the scheme itself was floated by the MIDC.
Exactly. So let the government explain.
It is. We'll satisfy Your Lordship. I'll try to convince Your Lordship that we are not obliged.
But even then, see.
No, we have already paid, Your Lordship. As per the third pay commission,
have not gone to the whole gamut of the matter.
Yes, Your Lordship.
What is apparent is this: time and again, you have, not you, maybe the government, through your correspondence, the MIDC, I mean, has indicated that this is the amount that is due. And
that is, we have proposed. That was a proposal made by us. That was not. We cannot demand from the government.
You cannot demand,
because we are not.
See, that in a sense is a commitment.
We have made a proposal that this is.
It may not have been. You may not be able to have.
Because we have no control of.
Because of
finance is not with us.
But that.
So we can only make a proposal that these are the proposed fund requirements, and whether if the government agrees to it, then they have paid whatever was they thought was deserving.
Finally, if the government is liable to pay it, then they have to do it.
That is to be seen, Your Lordship. After Your Lordship hears all the sides.
True.
All the parties, Your Lordship.
But Mr. Gautam, the counsel for the petitioner, hearing could not be completed today and will continue on the next date fix. As prayed for, list this matter after. Miss Silla is coming. She is out of station.
After 2 weeks.
2 weeks.
2 weeks.
Item number 7.
So where were we? Where have we reached?
We have reached to, my lord, the second, my lord, relating to para 86, 88 and 89 with regard to application of Assam Frontier Tracks regulation. Page number 175, 173. 173 in the paper book. Second issue was framed on the basis of this. Para 88 and 89, my reading. It may be pointed out that the vast tracts of land which was leased out to the appellant plaintiff club by the defendant respondent is situated outside normal area of Shillong, and it falls falls under the Assam Frontier Tracts Regulation 1880 at the time when the lease deed dated such 2023 was executed. The said tracts of land was declared as a backward tract by the notification published in 1929 under the Government of India Act 1519, where it is stated that the laws shall not apply to the said territories or any part thereof, or shall apply thereto subject to such exceptions and modification as the Governor may deem.
You're reading para 89?
89, 88, madam. 88. Page number 173.
Okay, that's why I was wondering. Okay.
Now, when we come down to 89, in view of the said notification noted above, the Transfer of Property Act 1882 is applicable only within the territorial jurisdiction of Shillong Municipality and Cantonment. The Transfer of Property Act has not been declared to be enforced outside the normal area of Shillong at the time when the lease deed sunset 1923 was executed between the parties. The lease deed dated sunset 1923 is not a valid lease deed, as the Transfer of Property Act is not enforced in territorial jurisdiction where the landed property is situated. Now, it says, my lord, the finding of the First Appellate Court is that TP Act was not applicable at the time of entering this perpetual lease deed, and this area was governed by the Assam Frontier Regulation, and therefore the lease deed was invalid. My humble submission, and pointed by my esteemed colleague also, that this is not the issue between the parties. It was not debated before the trial court also, and even before the First Appellate Court. It's not the issue. Now, the First Appellate Court robbed in this issue. Now, in view of this, my lord, even assuming that this finding is wrong, and lordship take it away, my lord, the perpetual lease deed remain the same. And within the perpetual lease deeds, that 10.19 acres remain the same. I'm not disputing. He will still occupy. He is still occupying even now today. Therefore, my submission is that this para 88, 89, it is incidental in nature, because this is not the issue between the parties. Because substantial question of law can be framed where the dispute is substantially an issue between the parties. And in view of the fact that this is not the issue between the parties, this cannot be the basis for framing the substantial question of law. That is my humble submission. Therefore, if lordship I am persuaded, my lord, that this cannot be the basis for framing the substantial question of law, then the second substantial question of law framed by this court will go away. Assuming that this
would have no bearing on the merits of the case.
Yeah, yes. Even assuming that yes, these two paragraphs can be the basis for framing the second substantial question of law, and lordship satisfied that yes, there is error on the part of the second appellate court, and lordship may remove this one. Still then, he fails to prove his case. About the Estopel section 115, that was the basis of the trial court order, it remains the same. About the, my lord, with regard to the location, he failed to prove. So on the merits of the case, still remain the same. And the least from the beginning, I'm not disputing. The dispute is beyond the listed area. And the appellant failed to prove that one. So if lordship remove these two paragraphs by exercising lordship jurisdiction under section 100 of the CPC, still, my lord, no benefit will go to him. Therefore, in short, it has no consequence. It will not take away. By removing these two paragraphs, will not take away the basis of the trial court order. Even the basis are taken away the basis of the first appellate order. Because if first appellate court render judgment solely standing on these two grounds, para 88 and 89, lordship, in that case, lordship may say that it is a substantial question of law. On that basis, the entire judgment goes. But admittedly, my lord, the basis of the first appellate court is not standing on these two paragraphs alone. He is firmly standing on the merits of the equality of the evidences. And lordship is very much aware that the first appellate court is the final court of facts on evidence. So he has entered into evidence I'll just point out those are relevant. I'll not read out those para. My lord, if lordship see with regard to location of the disputes where the plaintiff himself failed to disclose, where is the exact location of your listed area? Forget about my lord, the disputed area. My contention from the beginning, from the letter, is that the dispute is outside the list area. Now, even plaintiff failed to show where is the location of your the perpetual lease agreement. He failed to show. He even did not know the outside the disputed area. And that paragraph is paragraph, my lord, 69, 86, 91. Lordship may kindly pardon, I will not read it. Of the very judgment of the First Appellate Court. Para 69, 86, and 91 partly. That's the quality of the evidence. He failed to prove. Second is, my lord, the application of section 115 of the Evidence Act about the estoppel, because they in and out in front of him, 5 buildings were constructed. Yes. And he's standing for a long time. And he said he's not aware. Therefore, the trial court said, no, you're stopped now. Your action precluded you from raising this issue. That relevant paragraph, my lord, appreciated by the First Appellate Court also, para 65 and 71.
Yes.
My lord. So my lord, even if lordship removed this 88 and 89, my lord, the findings of the First Appellate Court on those paragraphs, 68, 86, 91 partly, 65, 71, and others also, my lord, it remains the same. It remains. Therefore, this para 88 and 89 has no consequences. No consequences. And my lord, the one important point, that is that regard the application of section 115 estoppel, they agitated before the First Appellate Court. And Appellate Court did not reverse that one, did not interfere while delivering the impugned judgment. Then what would be the consequences? My humble submission is that the finding and decision rendered by the trial court on the application of estoppel against the petitioner has reached its finality. They are not taking any plea before this Supreme Court in the second appeal. There is no such ground taken in the memo of appeal. So they have already waived. And that is the basis of the trial court judgment. So the finding on that application of section 115, well, in view of the fact that it is finality, First Appellate Court did not interfere. Therefore, my humble submission is this, that the consequential, incidental in nature, this para 88 and 86, 89, with regard to, my lord, other location para 86, lordship, I will not read. It is clearly mentioned there. So the lordship time will be saved. Now, in view of this para, my lord, 93, para 91, 92, may point out, ma'am.
Yes. Yes.
My lord, it says, may I read upon 91, the lease deed 23 life at both the parties is not the primary evidence, as defined under section 64 of the Evidence Act. It is seen that during cross-examination, Mr. Singh deposed that he was not aware of the location of the original document. Original document is a perpetual listed, my lord, and he did not produce before the court. It is, however, in their possession. From the evidence of Mr. Singh, it is clear that the lease deed was in the possession of the appellant plaintiff club. However, no reason was assigned as to who has prevented the appellant plaintiff from producing the original lease deed before the court as prescribed under section 65 Evidence Act, where secondary evidence relating to documents may be given. Hence, adverse inferences to be drawn against the appellant plaintiff for non-compliance within the provisions of law. Therefore, here, my lord, the First Appellate Court say that since you did not produce the original document, it is only secondary evidence, it is not primary evidence, so I cannot rely on. But this is the finding on facts by the first appellate court. And this finding on facts, my lord, there is no substantial question of law framed by this honorable court regarding this. And knowing very well, my lord, second appellate court will not enter into the finding of facts or on the merits. And this is purely based on merits. So lordship cannot enter into. Even if appellant is invited, my lord, to enter into, there is no substantial question of law frame regarding these findings. So I don't need to emphasize so much for this. Then in view of this, my lord, para 93, in view of the sub-discussions, reasons stated above, this court is of the opinion that appellant plaintiff has failed to establish a case that they are the lawful lessee in respect of the suit property and hold the suit property under the valid perpetual lease deed. This is exactly 93 is exactly the rejection of the prayer of the plaintiff. The plaintiff, the similar relief sought by the appellant in the plea. So the first appellate court said that we're not inclined to accept your relief. So this, my lord, my humble submission is that the finding arrived by the first appellate court, my lord, there is no substantial error where lordship would interfere in exercise of a lordship jurisdiction under section 100 CPC. And with regard to that ancillary nature, we just place one earlier I have cited also. The 2010 I have cited already, my lord, that on lordship cannot interfere with the impugn judgment by representing evidence. Not on equity jurisdiction also. These are already cited in the last occasion. That is 2010, volume 30. 2010, volume 30. I have already cited. Relevant para start from para 16. Just a moment. Even my lord, we have referred to para 24 relating to section 103 CPC.
Para 24.
Para 24 also. But my friend is not advancing argument on for lordship to exercise para 103. But for the sake, my lord, I have pointed out that the law is very clear that only lordship can exercise section 106, 603 CPC only if the core issue between the parties is not decided. Now the core issue between the parties which is not decided, according to me, it has been decided already by the trial court and by the second appellate court. Only, my lord, the appellate court is that the appellant is making an attempt to nullify the entire order by relying on the finding on the para 88 and 89 about the application of TPI, which is not substantial. It is only ancillary. Now that judgment, it's only one judgment, 2008, volume 8 matter. Para 13 में para 13 13 14 15 13 14 and 15. It said, well, it's a substantial question of law. Second appeals will lie in cases which involve substantial question of law. The word substantial prefixed to question of law does not refer to the stakes involved in the case, nor intended to refer only to the question of law of general importance, but refers to impact or effect of the question of law on the decision in the lease between the parties. Substantial question of law means not only a substantial question of law of general importance, but also substantial question of law arising in a case as between the parties. In the context of Section 100 CPC, any question of law which affects the final decision in a case is a substantial question of law as between the parties. A question of law which arises incidentally or collaterally, having no bearing on the final outcome, will not be a substantial question of law. We just pause for some time here. But therefore, even Lordship was para 88 and 89 taken away by the law. Entire judgment of the trial court and appellate court cannot be nullified. The clear-cut findings are there. The issues between the parties. But therefore, this is only in ancillary in nature. I would come down to para 14. Yes, the Lordship time. We may refer to the procedure relating to second appeal as evidence from sections and such in sunset matter. I'll come straight away to the next page. The Lordship time. The second appeal would be heard to the question of law so formulated, and the respondent can submit at the hearing that second appeal does not in fact involve any substantive question of law. The appellant cannot urge any other ground other than the substantive question of law without the leave of the court. Now, paragraph 15, may come to G. Deciding second appeals by reappreciating evidence and interfering with findings of fact, ignoring the questions of law. My lord, therefore, my humble submission, my lord, there is no substantial issues raised by the appellant here to interfere with the trial court, the first appellate court order. So the entire submission of the appellant would be, my lord, my submission is to invite my lord to reappreciate the entire evidence, which is not permissible. Therefore, the two issues framed by my lord about by the order dated, I'll conclude my submission. Order dated 12 October 2023. That number one, where the first appellate court can grant relief to the respondent in the appeal in the absence of any counterclaim or cross appeal. I've addressed this issue already. My humble submission, my lord, referring the trial court judgment, first appellate court, no relief was ever granted to me. Therefore, this first substantive question of law will not go in his favor. Second one, my lord, whether the provision of Transfer of Property Act having no application over the tribal areas of state of Meghalaya in view of the operation of the Assam Frontier Regulation Tract 1880. That is confined to para 88 and 89. It is ancillary in nature. Even Lordship will remove it. Entire case remain the same. He fails to prove. Principle of estoppel remains the same. And even the ground is not taken. Therefore, my humble submission, my lord, there is no merits in the instant second appeal. Therefore, Lordship may dismiss it. And
I'll be required to give a reply to the points that have been raised. I'll require some time for that.
Next week?
Yes, ma'am.
Heard Mr. Sangresul, Senior Counsel, appearing for the respondent. This matter is the hearing in this matter is yet to be completed and will continue in the next 8 weeks. This is matter to 1 week.
Request you list of cases.